Hi, everyone. Thank you so much for joining us. We'll be getting started in just another moment. All right. Well, everyone, thank you so much for joining us tonight for the latest Stop RadTech teach-in. This month, we're talking about the very timely discussion around reproductive justice and surveillance. For those of you who haven't attended our webinars before, STOP, the Surveillance Technology Oversight Project, is a privacy group based here in New York that, you know, fights for privacy using advocacy and litigation. RadTech is a meetup offering monthly workshops and teach-ins at the intersection of technology, social justice, and community. And for this month's topic, we wanted to talk about the fact that pregnant people are subjected daily to the scrutiny of their decisions regarding where they go, what they do, what they ingest, and how they regard their pregnancy. And this includes private sector surveillance, this includes public sector surveillance, and includes alarmingly police and prosecutors targeting pregnant people for their reproductive choices, uh, sometimes putting them in jail, trying to pursue other legal remedies. And recent anti-abortion bills at the state level go far beyond restricting access and really are trying to overturn Roe v. Wade, overtly criminalizing abortion providers and those who choose to terminate pregnancies. It, at this moment, this was a very alarming trend when Justice Kennedy retired from the Supreme Court, but obviously in the recent tragic days since Justice Ginsburg's death, this has become an increasingly urgent issue as the Supreme Court potentially will be positioned to remove the fundamental constitutional protections for reproductive choice. And this month, we have an amazing expert on the topic, Cynthia Conti-Cook, a tech fellow who is on leave from the Legal Aid Society and who works with the Ford Foundation on gender, racial, and ethnic justice teams to help build capacity to respond to the expanding use of surveillance. And as a civil rights litigator, Cynthia, has fought with the Legal Aid Society to protect civil rights. She had, done a ton of impressive work, but I think one of the most really incredible projects was something called CapStat, which is a public database that tracks misconduct by NYPD officers and actually provides some crucial transparency on that issue. And additionally, Cynthia is on the community advisory board here at S.T.O.P. So thank you so much for joining us this month. And I was hoping, just to start, if you could tell us a bit about your background and how you got to this line of work.
Happy to, and thank you so much for having me. I wanted to first emphasize that I'm speaking this evening in my personal capacity, not on behalf of any place that I've worked or have worked, that I work or have worked. I am approaching this research from my experience mostly in civil rights and understanding and litigating police misconduct. I don't actually myself have any background in the reproductive justice field or any cybersecurity expert knowledge or digital forensic expert knowledge. My experience comes from a civil rights attorney background. I started suing police and correction officers for brutality, for medical malpractice, false arrest, and other types of abuses at a small law firm in Brooklyn from 2007 till 2014. And that's when I joined the Legal Aid Society's Special Litigation Unit, where I led individual and class action lawsuits, mostly against the police department, but also against the Board of Parole, for example, for not releasing people on parole, and litigated issues about police misconduct that were system-wide, things that not just one bad officer did, but things that the police department fully endorsed. And that's from really that experience with understanding not how perhaps a system is put in place or the theoretical ideas behind which any state power is enacted, but on the flip side, how it often gets abused.
And that's so crucial because, if we push back on each one of these instances of abuse, it's important work, it's indispensable work, but it still means that countless other New Yorkers are going to face the same sort of brutality, the same sort of police misconduct. And it really does take, these sort of systemic responses to try to protect our community from that sort of police violence. But let's pivot to some of the work that you were doing in the reproductive justice field specifically. What sort of what connected the dots there for you between sort of the work you were doing on the ground as a civil rights lawyer and this broader issue of reproductive justice and reproductive surveillance?
So in 2018, I was a part-time fellow at Data and Society, and that really started to broaden my research and thinking about various types of policing and surveillance technology to not just think about the impact that it'll have on public defense or on fighting for the rights of people accused of crimes, but it made me start really thinking about issues of privacy and how digital rights and new technologies were going to increasingly escalate and marginalize people who have been historically oppressed. So that was really the pivoting point for me when I started to expand the idea of civil rights beyond just, like how personal interaction goes between a state actor and someone else. To really think about what systems were being put in place at the very high-tech surveillance levels that impacted us all.
So then tell us a bit about how then you were thinking about like the scope of your research when you were at Data Society and, this broader project and how you're looking at, because there's so many of these systems to choose from when you're looking especially at the NYPD and its sort of wide-ranging practices.
Sure. So in addition to understanding more about what it means to collect data on police misconduct, for example, I started to think about a lot of the implications of what it meant to have a digital device in our possession, usually on our person or in our vehicles or in our homes, that was connecting to something that was essentially run by a third party. From our experience in criminal defense, we know that anything that is being shared with a third party can very often be subject to subpoenas on the assumption that that information was not meant to be kept private, but it was something that was meant or expected to not have the protections of privacy because it was being shared. And so the concerns and future of legal privacy protections were something that sort of turned me toward looking at how digital devices and digital forensic investigation tools were going to start to be targeted towards populations like pregnant people, especially.
And I do think that's something that is worth dwelling on a bit, just this idea that we all are surrounded by this data that we're constantly creating, and there's this legal sort of fiction that somehow if I put that data on a website, it can be less protected under the Constitution than if it's on my own hard drive. And the idea that, and drawing these distinctions that would have made absolutely no sense to, people who drafted the Constitution centuries before any of these technologies existed.
Yeah, that's just why we have to really go to the principles that we have enshrined in law. And so, for example, one of the current legal doctrines that is really relevant to thinking about how technology can be used against us is the Supreme Court's decision in Carpenter 2 years ago already, I guess, maybe 3. And the Carpenter decision said that because the cell phone technology and the pings to various cell towers that our phones engage in when they're moving with us, that information alone, that location tracking information, can be used against us because it describes too much of where our physical mapping is going, and therefore could also describe our political affiliations, our religious identities, our sexual orientation, things about ourselves that we expect to be held private, because that location tracking was so intimately connected with our ability to identify ourselves in ways that we wanted to remain private. The court said that that location tracking data can be considered private, can be considered something we have a reasonable expectation of privacy in, even though we are technically sharing that data with the companies, with the phone companies that are providing that internet service. But what the gap in the logic following the Carpenter decision and how a lot of district courts have interpreted it, they have failed to make that same connection about the actual content on, for example, our search history. So even though the court recognizes that my location tracking device that I'm holding in my pocket, my smartphone, is describing or has the potential to describe things as sensitive as my political affiliations, religious identity, and sexual orientation or anything else, that same mental traffic that is happening when I'm using a search engine on the internet is not considered protected or not considered something I should have a reasonable expectation of privacy within. And it's really that gap in logic that is one of the largest issues, and one of the issues that will and has been leading to evidence from a woman's search engine history being used against her to show her mental state prior to a pregnancy outcome that the court or that the prosecutors have criminalized.
Yeah, and this is just one of those maddening areas of law where, of course, the judges are very old and not particularly adept at understanding the technology. And it's, even where you do get good case law, it lags so far behind where the technology is. And, in the interim, you just see so many people suffering because of these really abusive search practices. But let's go back a bit and just sort of talk about, the sort of situation you just laid out about someone's search being relevant, being something that prosecutors are looking at. How does that come into play? Tell us a bit more about how that technology is really impacting, reproductive justice and reproductive choices.
Well, let me back up to just identify two trends that I was seeing when I began to sort of do some research into this area. There is a lot of energy and excitement around abortion pills and their promise to increase access to abortion for pregnant people around the country. And they're mostly using online access to get those abortion pills. There's also a lot of organizing that's happening to support people seeking abortions, and most of it is also online organizing. Despite so much reliance on these digital tools, there's not a whole lot of available and sort of parallel information about digital surveillance and the privacy or the exposure that people really have when they are using these tools to either inform themselves about options that they have about their pregnancy and their reproductive health. And so when I started raising some of these questions with some organizations that I was speaking to, I was basically asked to elaborate, and it resulted in some research for this law review article that I've been working on. And one of the first cases that I encountered was the case of Latice Fisher, a Black woman from Starkville, Mississippi, who arrived at a hospital in 2017 with her stillborn fetus, and she was investigated and prosecuted for killing her fetus. In addition to a problematic medical test that by itself deserves an entire webinar, but I'll put an asterisk on that. The other evidence that was introduced in the grand jury in her case was evidence from a digital forensic extraction of Ms. Fisher's phone and her web browsing history specifically that included a search for abortion pills. Now, following advocacy from her excellent defense team, the prosecutor dropped the first indictment, which was for second-degree murder, and dismissed her case actually last June. So I think that the best way to sort of talk about what is happening in this area is to sort of touch on the past of how abortion has been criminalized in this country, and the present, which you've already mentioned, especially given the past week. We realized that 22 states in the past, even before this past week, there's 22 states anticipating that the Supreme Court is going to change its decision on Roe, already have enacted abortion prohibitions, sort of anticipating that the law of the land will change so that states, the decision about whether abortion is lawful will be, again, up to the states.
I mean, this is
right. And so like what this, I mean, it's not the future as in like the sci-fi future that might not happen for anyone. This is the present for many people. The current state of surveillance and the current state of how digital devices and the information that they collect about you can be used against you. That is the present for some people. It's the present for Ms. Fisher, but very definitely the future for all of us.
And it's just horrifying to contemplate that, people will be prosecuted under abortion laws that shouldn't exist, but on the basis of just supposition by looking at their digital searches, looking at their phone. I mean, it seems almost preposterous that would be enough for prosecutors to charge someone with a crime. But maybe that's my naivete as someone who hasn't done criminal defense work the way you have.
Well, there was a Florida case where the only connection between, the only evidence that was really presented was the digital forensic evidence of the roommate of the person who had died. And the evidence that was used, in his case, give me one second. It was a case where the location of the person who was killed, his body was very far away from the location where he lived. And the evidence that was used against this young man who was only otherwise connected to the victim as a roommate was the GPS location tracking. So they tracked his location from the area where they were both students to the area where the body was buried. And then they had a Siri search for, I need to hide my roommate. And they had the use of a flashlight app during the time that the police believed the body had been buried. And they also had the step tracking app that showed that for like the moments before the flashlight app was turned on, the holder of the phone went up a flight of stairs. And so the theory of the case was that the person was obviously not going upstairs, but going, up or down a ditch in order to get to the place where the body was actually buried. And so in that case, it was an example of when digital evidence was literally the only thing tying someone to as a suspect. There was another case in Virginia where the suspicion was completely based on Google reporting in a reverse geofence warrant that that person had been within the vicinity of a bank robbery and at the time of the bank robbery. And that case also is an example of the amount of power that these tools have to connect us to incidents that we are not necessarily involved in. There was another example of a reverse geofence search warrant being used to identify someone who is biking by a crime scene, but had nothing to do with it. These types of geofencing warrants are actually, the type of geofencing technology is also currently being used to identify anyone who's walking in or out of Planned Parenthoods. And that includes in New York City. And it's using that same type of ad tracking that I know if you've walked into a Walmart or a Target lately and suddenly you all of a sudden have like coupons popping up on your web browser for whatever store you just walked in, that type of geofencing ad technology, digital advertising technology, is being used to target messages, whether they are misinformation or whether they are harassing messages to people walking in and out of Planned Parenthoods. The Massachusetts Attorney General has sued the company that was doing this in the state of Massachusetts and settled the case for the agreement that the company would stop doing it in Massachusetts, but that of course doesn't have any power over what that company is doing in other states, and I haven't heard of any other states filing lawsuits to stop them from doing it here. So geofencing is yet another technology that's being used and weaponized.
Wow. And so when you're talking about geofencing in these sorts of cases, does that mean you're potentially both law enforcement, geofences, and private sector? And maybe just for folks who haven't heard about geofence searches before, just quickly describe what that is and why it's so particularly dangerous.
Sure. I mean, the geofencing technology is sort of yet another tool that the law enforcement can draw on, and that digital advertising corporations can draw on to make sure that they know if a certain demographic is walking into a certain type of place. So they can sort of triangulate a demographic that they want to profile along with a location that they want to know when that demographic walks in there. Which actually it's worth bringing up how particularly vulnerable a demographic pregnant people are in terms of their data collection, because pregnant people are online and they go online for a lot of reasons. They're actually one of the most valuable demographics for advertising companies to collect data about and to understand the profiles for, because it's likely advertisers believe that new parents are most likely to form new branding loyalty around the pregnancy or around the birth of a new child. And so the companies want to hyper focus on those specific demographics. And there was a study done by a socio-technological professor whose name I will find, and Janet Vitressi, and she did this experiment with her own pregnancy and tried to hide her pregnancy from the internet. In order to do that, she had to buy gift cards, use only cash for all her baby-related purchases, and not mention pregnancy in any social media, emails, or texts. And this required her to coordinate this rule across all family members and friends who were engaging with her. And if people slipped up, she had to enforce discipline amongst her entire network in order to protect that information from being churned into the monster of the internet and used to target her for advertising. And she described the process of actually having to avoid the internet as feeling like opting out made her look like a criminal. And her husband was even flagged one of the times that he went to purchase multiple gift cards at once. It created an automatic flag for a security alert. And you can imagine if the professor was a Black woman and was much more likely to be targeted if she attempted to buy multiple gift cards at the same time and had gotten that same automatic flag alert for her purchase. And it's really within this online environment where there's already, because of restricted abortion access and because of a lot of clinics closing down in very large rural states where having one clinic per state is really an unfeasible amount of transportation in order to get what you need. In those places, the online access is the access to abortion that a lot of people have. That's just the new reality for so many women. And as a result, that increased reliance on online tools and that forced exposure to the digital surveillance technology that's out there is what is creating a huge amount of vulnerability for people who are seeking even information about, let alone, medication abortion.
Wow. And I should add for everyone that we're going to have a Q&A session at the end of this, so please use the Q&A tool at the bottom of your screen to submit any questions that you have. I mean, so when you found out sort of about what was going on in Letice Fisher's case and use it, and with geofence warrants, what was the next step in your sort of your research project, and what did you discover in that process?
Well, the first question that I started to ask was just why are we all online for everything? We are all going online as the first place that we go to for all medical information. And Pew Internet and American Life Project actually reported in 2018 that 80% of internet users, which is 93 million Americans, search for some health-related topic online. And we are all using the internet for these purposes. We're all using it for the same reasons. It's so much easier to look up information about whatever random symptom you're feeling. I mean, we all know this right now more than ever, right? And expect to get faster and more reliable information than if we had to book an appointment with a physician and try to go to the office and try to, get an appointment and do everything that entails. The next thing that I looked at was really the demographic of pregnant people online and understanding how specifically targeted they are as a demographic. And so as a result of that, any conduct that they are doing online, anything that they are doing online, the mapping of their online behavior is being much more closely scrutinized, and their demographic is at the same time being more often and more correctly profiled. And the next step that I really took was to really think about all of the ways that people who are already over surveilled and historically oppressed interact with state actors who can at any point in their interaction try to search or seize their digital devices. And so while it might seem as like a leap for me to go from like searching for whatever weird ass thing I'm looking for in the privacy of my own home on my phone, to a reality where searching for something online about a medical condition can mutate into criminal evidence used against me. We really have to remember that so many young people in this country, especially young people from Black communities, Indigenous and Latino communities, and communities that are undocumented and historically oppressed, that they all are over surveilled, searched, and seized, not only by police, but by caseworkers from Child Protective Services, public healthcare workers, counselors, court mandated program officers, school security. All of these state actors play roles in surveilling people, and now are having more now than ever increasing access to surveillance tools that assists them in doing that, especially assist them into having insight into the digital devices those people are using. One example of this is Ebt Cards, so benefits cards. Much like our credit cards, Ebt Cards collect data on where the people that are holding them are spending their money. This allows and has translated, this was documented in Virginia Eubank's book, Automating Inequality. This is translated into policy proposals from some conservative governors restricting the types of establishments where people can spend their Ebt cash. This is one example of how data that's collected from people can be used against them in ways that the policymakers of that state choose. Police are also not just interested in physical searches anymore. More and more, we see officers not only go into people's pockets and illegally stop and frisk them, but remove their digital devices, ask for access to their digital devices. Consistently, for example, the Civilian Complaint Review Board in New York City receives reports that police are deleting data from digital devices and searching digital devices. We've heard reports from very young people in New York City that police pick them up, take them to a station for questioning on some pretextual arrest, and then leverage their liberty against getting access to their phones, their contacts, their social media accounts, and other info that's being held on their digital devices, even their former location. I'll pause.
It's a lot. It's a lot to take in. It's a whole ecosystem of tracking and control. And are there any other tools that you think are really important to understand in this space? Any other just basic definitions that are important to understand as we think about how reproductive justice is surveilled?
Yeah, so we've touched on location history, we've touched on geofencing, as well as digital advertising. And one other thing to know about digital advertising is that companies amass and collect redistribution packages of highly sensitive data or marketing and create marketing lists based on the status of profiles like rape victims, domestic violence victims, patients of specific illnesses. This is paired with data from large telephone companies, and it's possible for data brokers to even identify people from so-called anonymized data. The other type of tool is social media activity that's perused by law enforcement through special backdoors that allows police departments to, for example, do a keyword search in their jurisdiction. In 2014, following protests, month-long protests against the non-indictment of an officer for Eric Garner's death, and then following subsequent shootings of police officers, there was a dozen social media post-based arrests made against people for terrorist threats solely based on things that they said on social media. And the way that the NYPD got to those people and to those social media posts wasn't because they were so viral that everyone was sending them around and police officers happened to sort of see them in a large amount of profiles or something. It was because they were doing specific keyword searches for the words that they were then charging people with using that they considered terrorist threats. So social media is another entire area of information that can be weaponized against people for criminal prosecution. Wearables, Fitbits, Apple Watches, pacemakers, other types of wearables can be used as criminal evidence. In California, there was a Fitbit worn by a woman who was killed in her home, and it was used, the data from her Fitbit that showed a spike in her heart rate was used to argue that at the time of her death, at the same time there was, that it happened at the same time as her father-in-law arriving at the house per surveillance footage from across the street. There are many fertility and menstrual tracking apps on the market that collect, store, and share large amounts of data, specifically about reproductive health, menstrual cycles, physical symptoms, emotions, mood, body temperature. And for people that are using these fertility and menstrual tracking apps, it's really important to emphasize that this information is being collected because they're putting it through some sort of machine learning program that they say can help you predict, like when you ovulate and therefore when you're most fertile. But really the operation that these apps are doing is that they are serving as data collection devices for companies to gather that super, super priceless data on pregnant people.
And a lot of this, especially in terms of the inferences that are being made in the criminal process, just sounds like junk science. I mean, are prosecutors basically just speculating based off of this massive store of information to come to these random conclusions? Or like, it seems like it's in some of these cases, it's just like, well, this data point could be this, which could mean this. And so really anytime you're collecting more data, it seems like there's more opportunity for police and prosecutors to reach, the wrong result.
Well, we know a common adage amongst defense attorneys is that if you have a hammer, everything is a nail. And I don't know if you saw, but earlier this year, Google actually announced it was going to start charging police departments for the types of Google search engine subpoenas that they were getting, because they're getting such an overwhelming number of them from police departments are all across the country for all types of cases, that Google needed to start charging for it in order to deter police departments from using it for every single type of case.
And I just want to remind folks, we're going to be taking questions throughout that we'll ask at the end. So please don't hesitate to use the Q&A function at the bottom of your screen. So maybe you could tell us a bit more about how all this technology is changing the underlying, dynamic with criminalization of abortion across the U.S. Because it seems like these technologies are incredibly powerful, but there is this underlying, just pattern of discrimination and criminalization that long predates some of these invasive tools.
Absolutely. In America, by the end of the 19th century, every state except Kentucky had laws banning abortion on the books, including New York, which criminalized it in 1845. And even following 1973, when Roe legalized abortion, women continued to be criminalized for a wide variety of conduct related to their bodies during their pregnancy, including drug use, refusal of medical treatments, other interventions during pregnancy and birth, to the taking of different alternative medical treatments or to intentionally terminating a pregnancy outside of a traditional medical setting or clinic. Most of the people that are criminalized are low-income women, women of color, immigrant women, and women at those intersections. And of course, like we've said earlier, at this point, the amount of abortion access that will be restricted across the country seems highly likely. It is in this context that abortion pills, like I said before, have become very have been available online, and online access to abortion pills has been, as a result of all of the restrictions placed on abortion clinics across the country, a really important avenue for women to continue to access abortions. The Guttmacher Institute has all sorts of stats on the increase of self-managed or self-induced abortions or abortion using medication. And it's increased a lot over the past 5 years. And of course, also jumped during to COVID and to the increase in telemedicine across the board generally. But even for pregnant people that live around the block from an abortion clinic and can afford it and are in a state that protects their right to have it, buying abortion pills online is still attractive for many reasons. You don't have to tell as many, you don't have to sort of schedule it into your life quite as much. And it's private. You're ordering it online, you're getting the package delivered to your home, and where you can take the pills in privacy. So you don't have to bum a ride anywhere. You don't have to tell anyone. No one has to really know. But at the same time, that's wrong, because if we're not treating our smartphones with more caution, they are going to become evidence that's used against us.
So, I mean, I think like a lot of us, I've been in shock the last few days after the death of Justice Ginsburg. I can't begin to imagine what, as someone who focuses on reproductive justice, what it's been like for you. I just wanted to get a sense of how you feel this impacts the trajectory of the sort of surveillance you're seeing, and what does that mean for the future?
I don't think it's that different, honestly. This research I did over almost a year ago now, I think that a lot of these problems were going to be with us regardless.
And when you think about then the trends going forward, is it just more of the same then, more of these same technologies and even more invasions of our privacy as we see states try even harder to criminalize reproductive access?
Yeah, so the more devices that we bring into our homes, like the Alexas, the Google Homes, the smart water meters, the smart lights on, lights off stuff, other utilities that are sort of being, I don't know, smartified, drones inside houses, which is apparently now a thing you can get on Amazon too. All of these things that we are increasingly letting into our lives are creating new risks. Ring, right? All of the new devices that we are engaging with, that we are taking in, engaging with voluntarily, we are actually just creating more and more data for those companies that own those pieces of equipment and are really giving us a device by which they can collect more data. So the more that kind of convenience tool is introduced into our lives, the more surveillance will be introduced into our lives. There's other surveillance tools like automated license plate readers, biometrics, genetic data, DNA, home surveillance systems, which I just mentioned, and Bluetooth beacons, which we are all a little bit more familiar with now that we've heard of how COVID contact tracing works. All of the sort of like newer technologies are just going to introduce newer problems that we are going to need to solve.
Well, sounds like such a huge challenge. I know it can feel bleak at times, but what do you think people can do to push back, to fight back, to try to reverse the trend that we're seeing here on the ground?
Well, I want to lift up the work of our data bodies and the Digital Defense Playbook. I have a link to share in the chat with folks. That is an awesome contribution. Which room can I chat in? Oh, here we are. Um, that's a really good contribution, and it's a really good place to look for information. Your website, of course, has really great information for people that want to know how to safely engage or more safely engage with digital tools. The Electronic Frontier Foundation has a surveillance self-defense website that has excellent information on it. And there's also new tools coming out, like the Blacklight by Markup that just came out on ad tracking is a really excellent way to become a little bit more familiar with the reality that we're all having every movement on the screen, whether it's with a mouse or with your finger, really tracked and dataized, I don't know, turned into data that is being used to track our movements and our thoughts, patterns, and our behaviors. The other, I mean, the good news I would say is that there's new conversations that I'm hearing. I heard a conversation the other day where somebody was like, I'm not going to Google that and do that to my Google profile. You do that. You Google that if you want to know the answer to whatever weird, obscure question. And that kind of like new awareness or naming that awareness is the kind of, not paranoia, but awareness that we need to have with every engagement that we make with our digital device has to be sort of with the recognition that it is tracking our movement, it's tracking our questions if we're asking things of it in our search queries, and it's tracking a lot of the social networks that we're building over multiple social media platforms, as well as our contacts.
And since as a lawyer, our hammer is law, and so we always see that as the solution to everything. Do you think there are legal solutions that people can promote as well?
There are, as you know, there's several new privacy laws that try to address the issues of biometric data collection and other digital information across the internet. The problem is that as good as those movements are and as important as it is to protect our privacy from corporations and other commercial interests, a lot of those laws have exceptions for law enforcement. And so I would recommend, with whatever law reform work people are doing across the country and technology, to really emphasize that, think about, like, would this have protected Ms. Fisher? Would this have protected other people who've had their digital evidence used against them in criminal court? And if not, then it's not going far enough.
Yeah, that tends to be something that we see quite a bit here in New York, particularly, where people are quick to say, okay, privacy is great, except for the NYPD. There's always that caveat. All right, let's go to some of the questions. So Miguel asks, hello, can you speak to how easily geofence warrants are granted to police? Also, are there any guidelines about how that data is used and evidence is presented?
Hard question. Thank you, Miguel. It's typically up to whatever judge the police or detectives are coming to for permission to get a warrant if what they're seeking is a warrant. If what they're seeking is a subpoena, usually they don't need a judicial subpoena for a subpoena to Google, for example. So I hope that answers your question about how easily it can be done. It sort of depends on the facts and the intensity of the judicial inquiry. I can tell you from experience, it's not typically very aggressive of an inquiry, even though I'm not present for it. We're just present for sort of like the consequence of it. The second part of your question, can you remind me of the second part of the question? Is it in my notes?
Are there any guidelines about how that data is used and the evidence is presented?
I have not myself seen it used in a case where I've had like actual direct eyes on what it looks like, but I do know that the in the reverse geofence case in Virginia, that Google fought very hard for a very limited amount of data to be shared, and claimed that more access to how they exactly got to this person being the suspect would be proprietary and violate trade secret laws. And that is, a whole other topic for probably another webinar. probably with the wonderful Rebecca Wexler, who wrote Life, Liberty, and Trade Secrets, and writes very well about the problem of corporate industries and companies invoking trade secret laws in criminal justice proceedings.
All right, we're definitely going to have Rebecca on as well. I'm a huge fan. One thing I wanted to flag is there was actually a really exciting court decision out of the Northern District of Illinois about 2 weeks ago on the Geofence warrant front. It's from Magistrate Gabe Fuentes. And that decision was really striking in that it was, the third time in a row that a magistrate in that court had denied a geofence warrant request for being overbroad. So they asked for this huge pool of data and they got shut down. And then they asked for this slightly less huge pool of data and got shut down. And this third time they still got shut down in a ruling that really raised the question of whether, at least, for that judge in that court, whether they would ever find that geofence warrants are constitutional. And, obviously it's just one judge in one court, and we still see other judges that rubber stamp, reverse, search warrants, geofence warrants that impact, tens of thousands of people. But it's good to see that the courts are starting to get educated on the issue, at least bit by bit.
Yeah, there's a law review article that I think was called the Magistrates Revolt. And the idea of it was that magistrates were sort of judges were getting hip to the fact that giving a search warrant for a phone wasn't as simple as like looking up the phone numbers in your phone, and that it now encompasses so much of our life. And this was really recognized for the first time in 2014 in Riley v. California. It's the first time the court really recognized that our phones are not just phones anymore, that they are very elaborate diaries, calendars, and windows into the soul, as one digital forensics expert calls them.
Yeah, that opinion. Judges love coming up with tortured metaphors for what technology is. And there's so many analogies in that case to what is a billfold, what is not a billfold, because they keep trying to make it sound like a wallet and compare it to a wallet. It's somewhat absurd, but they come out in a good place there. Just as a reminder, folks, if you want to submit a question, please use the Q&A dialogue at the bottom of the screen. The next question comes from one of our favorite people, Anonymous. So Anonymous asks, says that they're a doula and birth worker and a professor who studies archives, and wanted you to talk a little about the trend of Black home birth photography and the right to birth at home alone, and could that be prosecuted in the future based off of personal documentation practices? As a second part, if the right to determine pregnancy outcomes is under threat, what does that mean to the right to give birth?
Yeah, wow. That's a fantastic question. Oh, it went away from the screen. It's okay. I definitely think that there are probably jurisdictions, and I say this with a lot of respect for people who work in reproductive justice. I'm not one of them, and so I'm not up to date on where exactly all of the various, horrendous laws are throughout the country. Perhaps some of you in the chat room are and can help, but I imagine that there are jurisdictions where it is possible to be prosecuted for not having a certain amount of medical intervention in your pregnancy. It's definitely been something that people have been, like the refusal for medical treatment or the failure to get some sort of medical treatment during your pregnancy has certainly been the conduct for which pregnant people have been prosecuted in the past in the research that I've seen. And there was one thing that I was looking at was this strange wearable called, I forget what it was called. I'm sorry. It goes around a pregnant person's midriff and is like strapped onto them and detects it. It says that it can detect just like, health status details about a fetus from inside, like whether it's heartbeat or something else. I'm not sure of exactly what the medical data points it says that it collects are, but nevertheless, this thing is made by the same company that makes a little like foot cover for an infant, and that infant can wear the foot cover in its crib, and then much like the monitor, the foot thingy will, this is my medical definition of the thing that they made, the foot thingy will tell you through an app the medical stats of your infant while it's sleeping. So same company that makes this sort of like pregnancy wearable also makes this infant wearable that collects data on the infant. Now this company has not been like, it's not prescribed, right? Like doctors aren't telling people that have had babies that they have to use this, but it's been suggested. And in a case that I forget exactly what state it came from, but there was a case I read about where an infant had died in the crib, and part of the woman was not prosecuted for this infant's death, but the comment section of the news article about the infant's death, and that news article said that the woman was told by the doctor to use this contraption but didn't, and the comment section was where she was criminalized, where she was like socially criminalized, right? And people said things that like, oh, she didn't follow doctor suggestions, it's the equivalent to committing a crime. So I can certainly imagine that in that, you know, unfortunately, the beautiful home births that are being photographed and the, you know, empowering experiences that those might be could, for some prosecutors that feel, you know, very morally ignited and righteous about medical birth, might seek to prosecute that kind of documentation, or that kind of conduct. And then the documentation, of course, is not the conduct itself that would be criminalized. The documentation would just potentially provide, if it was accessed by an adversary, the evidence that they might bring against the pregnant person for not having medical treatment.
That's just stunning to me. That I mean, it sounds like completely unproven tech, and and I highly doubt any of it's FDA approved. And the idea that people are going to be, you know, criminalized or informally criminalized as a result of it, it's just ludicrous. It's enraging. And again, a reminder, if you want to ask questions, please use the Q&A tool at the bottom. But I'm just thinking, it reminds me of the shaken baby scare of the 90s and the number of people who were prosecuted during that panic, even though there was never any scientific evidence that, you know, the babies were actually harmed by their caregivers. Do you see any parallels to that catastrophe?
I have to admit, I was partially reading what was in the chat room. Can you just repeat the question?
No, I was just wondering if you saw any parallels, you know, especially with, you know, the case you mentioned of the young child that unfortunately passed away, and the mother being attacked for not using this really questionable health tech. If you saw any parallels to the pseudoscience that drove the shaken baby syndrome crisis in the 90s, where you saw parents being charged under a medical theory that was later completely debunked.
Yeah, there's definitely a lot of narrative that's built in the same manner around those types of cases, right? And the lack of scientific validity never stops a prosecution from going forward. I think that what's so important about recognizing the role that digital evidence will play is that previously, if a woman walked into a hospital and she was, you know, reporting symptoms of a miscarriage, she just was, you know, going to possibly be interrogated by a nurse, possibly interrogated by a police officer that nurse calls, but it, at best, right, for the prosecution was going to be a prosecution where the charge was based on the medical records that showed a miscarriage, statements that maybe were made to a nurse or to a police officer, but the evidence was really going to not tell anything or reveal anything about what was in that pregnant person's mind days before, weeks before, months before they were arriving at that hospital. And so when so many prosecutions sort of already rely on tenuous medical theories, for them to also be able to go into a digital device and cultivate evidence from wherever they think that they can get it inside of a phone, when they think that they can go in there and really like drag up this information that, like I said, a digital forensics expert described as a window into the soul. They can go into the soul of your phone and take out your thought processes prior to you arriving at that hospital. That's an amount of intrusion into our mindsets that has never really been experienced before.
Well, I know we only have a few minutes left, but I wanted to, I saw there was one question in the chat that came in asking about misuse of fetal harm laws to prosecute pregnant people. Could you talk a bit about the role those laws could play?
Yes. So in like the next phase of this research, what I'd really like to look at is exactly that, is to how technology would really enhance the ability of prosecutors to target pregnant people for any conduct during their pregnancy, even conduct that doesn't result in a pregnancy outcome like termination. So, for example, there have been pregnant people across the country that have been prosecuted for things like smoking cigarettes or drinking alcohol or using substances to self-medicate. They have also been prosecuted for engaging in reckless conduct like getting in a fight. So there's a million other ways, and these fetal laws that you mentioned are really used to be able to victimize the fetus in a way that makes the pregnant woman susceptible to being criminalized for conduct in relation to that fetus as if it was a person, as if it had those personhood rights. And so it just opens the door to all categories of conduct that a woman might engage in during pregnancy being prosecuted as reckless conduct towards the person of the fetus.
Wow. And I know we only have a couple minutes left, so I wanted to just ask what you think the biggest takeaways are when you're thinking about all of these different threats to pregnant people.
I would say the takeaways are don't share digital devices with any police or state worker. Don't share passwords, passcodes. Don't open your phone to consent to your phone being opened. Use passcodes instead of face or fingerprints. Use encrypted and communication apps. Use VPNs if you can afford to. Don't do sensitive work on Facebook groups or other social media group sites, even WhatsApp. Even when you think that they're private, think about the risks and exposure to the person most likely to be criminalized and not just yourself. And the last thing is really that like these fundamental problems are racism, white supremacy, and patriarchy, and not necessarily technology. So while we obviously need to work on getting digital rights named and secure our rights from surveillance and the amount of scrutiny that corporations and the government currently have over us, it's just as important to continue really being laser focused on racism, white supremacy, and patriarchy more than anything else. It was a Freudian slip to slip from patriarchy to patriotism. Whoops.
There seems to be a slight connection. No, but I thank you so much, Cynthia Gondika, for joining us this month, for helping us delve into this just terrifying world of reproductive surveillance, and giving folks so many steps they can all take. And thank you all for tuning in for this month's RadTech meeting, and really hope you'll join us next month for the next session in this ongoing series. Have a good night.
Thank you.